2 weeks ago, we examined what commentators believed could be the financial consequences of the legal proceedings involving Prince Harry. At the time, many estimates focused on a potential gap between legal costs and available insurance coverage. However, as legal analysts continued reviewing the judgment and trial record, attention shifted away from a single figure and toward a more important question: how would the court assess costs? That distinction matters because, under English civil procedure, the basis on which costs are awarded can significantly affect the final amount. The upcoming costs hearing was expected to determine not only how much would ultimately be payable, but also the legal framework the court would apply. During the trial, one issue that attracted attention involved Prince Harry's evidence about past communications with journalist Charlotte Griffiths. According to the published court record, Harry testified about the nature of his relationship with Griffiths and his recollection of communications that had taken place years earlier. During cross-examination, lawyers for Associated Newspapers presented archived Facebook messages which they argued were inconsistent with parts of his recollection. Prince Harry's legal team maintained its overall case, while Associated Newspapers argued that the documentary evidence should be preferred wherever there appeared to be inconsistencies. Ultimately, it is the court, not commentators, that determines what weight should be given to any witness's testimony and to the documentary record. For legal observers, the significance of this exchange extended beyond the underlying claim itself. They noted that a judge evaluating costs may consider the conduct of the litigation as a whole, including the credibility of evidence presented during the proceedings. Understanding the costs. Hearing legal experts often describe 3 broad approaches a court may take when awarding costs under English civil litigation. The first is the standard basis, under which only costs considered reasonably incurred and proportionate are generally recoverable. The second is the indemnity basis, which may be awarded in more unusual circumstances, where the court concludes that aspects of a party's conduct fall outside the ordinary course of litigation. On this basis, the assessment can become more favorable to the successful party. Exactly which basis applies depends entirely on the judge's assessment of the evidence and the conduct of the proceedings. It is not automatic, nor is it determined by public commentary. Because of that, legal analysts closely followed every aspect of the trial record, recognizing that findings made during the substantive case could influence the later costs decision. A broader context. This legal debate also renewed interest in earlier reporting about the Sussexes' approach to the litigation. In 2024, People magazine reported, citing a former Archewell employee, that Meghan reportedly wished Harry could move beyond the ongoing lawsuits and focus on life after years of legal disputes. Those reports reflected the views of unnamed sources rather than public statements by Meghan herself. Even so, following the court's judgment, some commentators revisited those reports, arguing that the financial risks associated with prolonged litigation had become more apparent. Whether that interpretation proves accurate ultimately depends on the court's final determination regarding costs and on any future developments in the case. As the hearing approaches, the central question is no longer simply who won or lost the original lawsuit. Instead, attention has shifted to the consequences that follow, and how the court will assess the overall conduct of the litigation before determining the final costs order. One of the most closely discussed moments of the trial involved Prince Harry's testimony about past communications with journalist Charlotte Griffiths. During cross-examination, Harry was questioned about whether he had used the online name Mr Mischief and about the extent of his contact with Griffiths more than a decade earlier. According to the published court record, he said he did not recall using that name and expressed uncertainty about the communications. Lawyers for Associated Newspapers then introduced archived Facebook messages that they argued contradicted portions of that recollection. Those messages, presented as evidence during the proceedings, became a focal point of legal commentary because they offered contemporaneous records that the defense said differed from Harry's testimony. Whether those differences reflected an innocent failure of memory or something more significant was ultimately a matter for the court to evaluate. Legal observers noted that judges assessing litigation costs can consider the overall conduct of the parties throughout the proceedings, including how documentary evidence compares with witness testimony. For that reason, the exchange attracted attention well beyond the trial itself, with many analysts suggesting it could become relevant during the later costs hearing. Another major issue emerged during the proceedings involving a witness statement attributed to private investigator Gavin Burrows. That statement had formed part of the wider body of evidence relied upon by several claimants in bringing their case. However, when Burrows later gave evidence under oath, he disputed the document's authenticity and said he had not written the statement presented in his name. According to reports of his testimony, he also challenged the signature appearing on the document and stated that it did not accurately reflect his evidence. Associated newspapers argued that Burrows' testimony significantly weakened key parts of the claimant's case. The claimant's legal representatives disputed aspects of the defense's interpretation, leaving the court to determine what weight should ultimately be given to the evidence. Regardless of the competing arguments, Burrows' testimony became one of the most closely examined moments of the trial because it raised important questions about the reliability of evidence presented during the litigation. Why the costs hearing matters. Legal specialists have emphasized that the upcoming costs hearing is distinct from the original judgment on liability. Instead of reconsidering the underlying allegations, the court will decide how legal costs should be allocated after taking account of the conduct of the proceedings. Broadly speaking, courts may award costs on different legal bases depending on the circumstances of the case and the judge's assessment of the litigation as a whole. The decision rests entirely with the court after considering all of the evidence, submissions, and applicable legal principles. That is why commentators continue to examine moments such as the disputed Facebook messages and the evidence relating to the Burrows statement. Whether either issue ultimately affects the court's decision on costs remains a question that only the judge can answer. Level 3. Punitive indemnity, no cap. The court determines the losing party's conduct was so far outside acceptable norms that the full recoverable amount has no mathematical ceiling. The Daily Beast, July 7, 2026. There is a live grenade still rolling around the courtroom floor. If Nicholin makes findings of serious misconduct over the fabricated statement allegations, the Mail can seek costs on the punitive indemnity basis, blowing past the cap entirely. Blowing past the cap entirely, the $22.6 million gap from our previous video was calculated at level 2. It assumed capped costs. At level 3, the cap disappears. The $22.6 million becomes a floor, and the question stops being, can the insurance cover the gap? The question becomes, what does the court find Annal reasonably incurred across 46 days of trial with 40 journalists cross-examined? That's not a number anyone has calculated yet because nobody knows if level 3 applies until July 29th. This wasn't even close. It was a slam dunk. Lots of people thought the judge might just give Harry sort of a win on one of the 14 just so he had something to walk away with, but he didn't get that. This is a total destruction of his case, and I believe his reputation today. Well, and you raised a lot of interesting points, I must say. And you mentioned his reputation. I mean, he hasn't done an awful lot to enhance his reputation in the last few years. If you think the uncapped costs exposure is the full extent of what's heading toward the Sussex operation, wait until you see what they did in December 2025, when they already knew how bad this was getting. That's in 5 minutes. And it proves they understood the risk before the verdict ever landed. But first, the secret exit attempt, because they tried to leave before it exploded. Revelation 4, the exit. They couldn't get the times. July 8, 2026. One day after the verdict, Prince Harry and 6 fellow claimants sought to negotiate a settlement with Associated newspapers through unofficial channels. Representatives acting for the Duke of Sussex enlisted a retired senior police detective as a go-between to approach the publisher before Harry was due to testify. The group made their initial approach last December. Associated newspapers flatly refused. December 2025. The Burrows statement had already collapsed in the courtroom. Harry's Mr Mischief testimony was weeks away from being contradicted, and the claimant's representatives, not lawyers through formal channels, but an unofficial go-between, were trying to negotiate an exit. One proposed outcome: both parties might simply walk away from the litigation, each bearing their own costs. Walk away, each paying their own bill. Annal refused. They knew what they had. 3 weeks later, Harry took the stand and said he never used the name Mr. Mischief. Annal produced the messages. The trial ran its full 46 days, and every single allegation was dismissed. You don't send a retired police detective through unofficial channels to negotiate a walkaway if you believe in your evidence. You do that when you know the evidence is collapsing. And then when the exit fails, you testify anyway and hope. Now, let's put the August 2024 Meghan warning next to everything you just heard, because the woman who said let go was describing a case built on allegedly forged evidence that her husband's team was already secretly trying to escape. Revelation 5, the warning that has context now August 2024. People magazine, former RQL Foundation employee, Meghan supports Harry 100%, but she wishes he could let go of these lawsuits, be happy, and live in the moment. She wants him to be free of all of this, but she also knows that because of everything he's been through, and his love for her, and their children, he can't. In August 2024, nobody outside the legal team knew the Burrows statement was allegedly fabricated. Nobody knew the Mr Mischief testimony would be contradicted in open court. Nobody knew the Mischief 2025 settlement attempt would fail. But someone inside the operation knew enough to issue a warning through People magazine. Someone knew the case was fragile enough to plant the let go message publicly, while there was still Netflix money to absorb a loss. Now read the same quote against the current financial position. Netflix equity gone. March 6, 2026. Tumming 1920. Sussex lifestyle cost $45 million per year. Anal exposure at level 22. $6 million. Anal exposure at level 3. Punitive indemnity, no cap, determined July 29. The warning was issued when there was money to absorb a capped loss. July 29 arrives when there isn't, and the loss may not be capped. She said he can't let go because of his love for her. She wasn't in the room when it all came down. And the lawsuit she wanted him to drop was built on a document his own team allegedly forged. Prince Harry seems to want the public to buy into that every story about him and his family has been gained illegally by terrible journalists. You know, it's just not true. The collateral damage dates and numbers. 2021. Burrows' statement produced by claimants' legal team becomes the document that convinces 7 claimants to sue Annal. August 2024. Former Arwell employee tells People Meghan wishes Harry would let go. Netflix money still active. October 2022. Lawsuit filed. 7 claimants, $50 million in eventual costs. December 2025. Harry's team uses retired police detective as unofficial go-between. Annal flatly refuses the exit. January 14, 2026. 46-day trial begins. January-February 2026. Harry testifies never used the name Mr. Mischief. Annal produces Facebook messages contradicting this under oath. March 2026. Burrows testifies his statement was fabricated and his signature forged. Press Gazette publishes his exact words. March 6, 2026. Netflix exits as ever equity partnership. March 26, 2026. Betrayal published. $3 annual Sussex need documented. July 7, 2026. All 97 allegations dismissed. $50 million costs announced. Harry calls it whitewash. Meghan in California. July 8, 2026. The Times publishes the settlement attempt. Campbell warns of indemnity costs. Daily Beast identifies punitive indemnity as live possibility. July 29-30, 2026. Costs hearing. 3 outcomes possible. Burrows' fabrication and Mr. Mischief testimony are the 2 determining factors. 3 categories, no speculation. Category 1, the Three-Law standard costs capped. Proportionate, limited indemnity costs, lower bar recoverable. Campbell warned it's available. Desmond precedent $40 million, punitive indemnity, no cap, available if Nicholin finds serious misconduct. Fabricated Burrows' statement and Mr. Mischief testimony, contradiction, are the 2 specific triggers. Daily Beast blowing past the cap entirely. The $22.6 million gap was level 0.2. Level 3 has no ceiling. Category 2 joint and several. Tim Worstall. July 8th. Legal costs are usually joint, blanc, and several, so the winners just go after whichever loser has the deepest pockets. Arnold doesn't divide into 7 equal shares. They pursue the easiest recovery first. And the individual who testified under oath that he never used the name Mr. Mischief, directly contradicted by produced evidence, faces the most specific conduct finding of any of the 7 claimants. That's not a random distribution question, that's a targeting question. Category 3. The Meghan commercial consequence Bowers betrayal. $3 million annual need income drying up, as Ever's commercial premise is Royal Association. Netflix equity gone. Hirove produced no photograph. UK visit generated 0 Royal Association content. A cost determination at level 3. Punitive indemnity, no cap. Arrives at the exact moment the commercial operation has the least documented revenue and the highest documented expenses. And the let go quote identifies Meghan as the reason Harry couldn't stop. The case she wanted dropped was built on a document a sworn witness called forged. The trial she wanted avoided produced testimony contradicted by Facebook messages. Her warning was right. Her consequences are real. July 29th puts a number on both. Here's the calculation. Once our previous video identified $22.6 million in uncovered insurance heading into July 29th, that number assumed capped 2L's costs at level 2. 2 pieces of courtroom evidence changed the equation. Harry testified under oath he never used the name Mr. Mischief. Then Annal produced Facebook messages proving he did. Gavin Burrows testified under oath that the key document launching the entire $50 million lawsuit was fabricated by the claimant's own side, and his signature was forged. If Judge Nichollen makes findings of serious misconduct based on those 2 pieces of evidence, Nell can seek punitive indemnity costs, no cap. The $22.6 million becomes a floor. In August 2024, Meghan's circle told people she wanted Harry to let go. In December 2025, his team used an unofficial go-teen to secretly try to exit. Annal refused. The trial ran. The evidence collapsed. The verdict was total. The warning was issued when there was still money. The hearing arrives when there isn't. And the number may not have a cap. So here is my question. One specific answer. The Burrows statement was allegedly fabricated by the claimant's legal team. Harry's Mr Mischief testimony was directly contradicted by produced evidence. Both sit on Judge Nichollen's desk, heading into July 29th. If the legal team knew the Burrows statement was fabricated before the trial started, and they tried to secretly exit in December 2025, why did they let Harry take the witness stand and produce testimony that Annal immediately contradicted? Tell me what you found, not what you believe. What you found?